Thank you very much for coming in today's session. I'm going to be chairing this one and asking the gentleman here all the questions to come. I'm Effie Lounta. I'm a director with the Quantuma Disputes Investigations and Valuations team, and I have more than 14 years of expertise in disputes and investigations, and my expertise is open source intelligence and asset tracing, so I'm going to be covering the investigation side of the discussion. Next to me is Kate Smith. He is a managing associate with Keidan Harrison, a London-based disputes boutique. Kate's practice focuses on substantial and complex banking and financial services litigation, as well as contentious insolvency and asset tracing. His recent cases include applications for anti-suit relief, claims for after-acquired property and corresponding enforcement, and multi-party fraud proceedings involving alternative claims for transactions defrauding creditors. It's a mouthful. And next is Gavin Pearson. He leads the Quantuma Disputes Investigations and Valuations team. He has more than 20 years of experience acting as a forensic accountant and expert witness, and he has given evidence on more than 25 occasions in a variety of courts and tribunals. And last but not least, Zach Kell is a barrister practicing at Radcliffe Chambers, who specializes in civil fraud, commercial disputes, and contentious insolvency, often with a cross-border element. His recent cases include a 1.4 billion fraud claim relating to the Disney movie tax deferral scheme known as Eclipse, which was featured in this year's The Lawyer Top 20 Cases. He's ranked as a leading junior in the recent edition of the Legal 500 for banking law and civil fraud. So, what is Section 423, Zach?
Well, thank you, Effie. Section 423 of the Insolvency Act 1986 is, as ICC Judge Prentice said in Hunt and Balfour Lynn a couple of years ago, inaptly headed transactions defrauding creditors. So that's a good start. Fraud is not the watchword here. There are two boxes that we're looking to tick to get us into the zone, as I'll call it, the appropriate zone for a 423 claim. First, we're looking for a transaction entered into at an undervalue. That's a transaction between a respondent R and a third party P, where R makes a gift to P, or R otherwise enters into a transaction with P on terms that provide for R to receive no consideration, or R enters into a transaction with P in consideration of marriage or the formation of a civil partnership, bit of a rarer circumstance, that one. Or finally, R enters into a transaction with P where the value of the consideration passing from the third party P is significantly less than the value of the consideration passing from R, and you judge that in money terms or in money's worth terms. The second box that we need to tick to get into the zone is that the court has to be satisfied that the transaction was entered into for one of two purposes. Either one, to place assets beyond the reach of a potential or actual claimant, or two, to prejudice the interests of a potential or actual claimant in relation to the claim which they are making or may make. And a little bit later, just to foreshadow the questions that Effie is going to ask me, I'll be talking about freezing orders and the usefulness of freezing orders in these types of cases. And just pausing there, you can already understand why a freezing order may well be very useful for this type of claim. As I've explained, there is no requirement to plead or prove fraud, despite the frustrating title of the section. Therefore, it's easier to run a 423 claim in terms of the evidential hurdles, and it can be usefully used alongside or as an alternative to a typically trickier fraud action. Bearing in mind that 423, as I'll again foreshadowing some of Effie's questions, I promise they've not all been shed, 423 has a very broad range of remedies and so can be used to unravel, maybe not all, but most things. Also, whilst it's of course contained in the Insolvency Act, these claims do not require an insolvency context. A claim under 423 can be and is used in a variety of general commercial matters. It's even been used in matrimonial property disputes, for example, the Akhmedova case, that I've referenced on the slide. And that's a judgment that I commend to all of you to read, in which Mr. Justice Knowles wonderfully opened his judgment by saying, all happy families are alike. Each unhappy family is unhappy in its own way. Of course, Anna Karenina, for those literature nerds like myself. He goes on to say, with apologies to Tolstoy, the Akhmedov family is one of the unhappiest ever to have appeared in my courtroom. And that was a very interesting case in which the divorced wife had the benefit of a 450-odd million pound order against the former husband. And she was taken to have to sue her son's company in Cyprus, and several trustees who'd set up structures to help the malfeasant husband evade paying that rather large bill. So very interesting, very fun judgment to read. What I will say, though, however, is one must be careful when using it in all contexts. There has been a case up on the slide again, the Hall and Nassim case from about 3 years ago, where 423 was used as a backdoor to bring a form of tax challenge. So don't take your imagination too far with the section, but there's a little whistle-stop tour as to what it is.
Who has a standing to bring a Section 43 claim, Zach?
Well, it's important to remember that the possible applicants are prescribed under 424. Where you see reference to the word victim in the context of these sections, that's the person who is or is capable of being prejudiced by the transaction. And a debtor in this circumstance is the person R that I've been talking about. So that's 423 sub 5. We have three classes of case to consider when determining if someone has the requisite lockers to bring a claim. So the three of these. First, there are cases where the debtor or R has been made bankrupt, is a company which is being wound up or placed into administration. And in that context, a claim can be brought by the OR, the trustee in bankruptcy, the liquidator administrator, as the case may be, without the leave of the court. But that's not the end of it. A victim of the transaction may also bring a claim, but they will require the court's permission in those circumstances. So when you're representing a victim that's coming under that section, you have to think pre-action. Does this claim have legs? I mean, in all the other cases you should. If you're representing an insolvency practitioner, you certainly shouldn't bring a faulty 423 claim, but that's something you'll have to address to get the court's permission to bring the claim on behalf of the victim. Second, there are cases where a victim of the transaction is bound by a voluntary arrangement, CVA, IVA as relevant. There you have a claim that may be brought by the supervisor of the arrangement, unsurprisingly, or by any person who, whether or not bound, is such a victim. There you don't require permission. And third, there are cases which fall out with those first two, so very, very broad range, and in that context, a victim may bring a claim, again, without permission. Section 423 happily has extraterritorial effect for those of us that are cross-border lawyers, and that's the Begum case up there, although I will caution when reading that, that's a judgment on an application to amend pleadings, but there's been nothing to challenge that in principle. It needs to have a sufficient connection, though, with England and Wales, unsurprisingly. That's the Kazakhstan, Kagazi and Zunas case, and the court will look at a range of circumstances when deciding whether or not it has that sufficient connection with England and Wales. So they'll look at the residence and place of business of the defendant, they'll look at his connection with the insolvent, they'll look at the nature and purpose of the transaction being impugned, they'll look at local law considerations and any assets that the respondent may have fair title to that is unimpeachable. So a wide shopping list of things that the court is going to look at to decide whether it is connected to England and Wales. And again, it's worth reading that judgment from then Mr. Justice Zaccarelli, now, of course, Lord Justice Zaccarelli, who sets it out very, very clearly for you in that case.
So what are the court's power in a Section 43?
Well, if you get into the appropriate zone, as I started with, then the court retains a discretion. It may make an order as it thinks fit for one of two things: restoring the position to what it would have been if the transaction had not been entered into, and protecting the interests of persons who are victims of the transaction. So far, very, very broad. The Act actually provides a menu of 6 possible orders or remedies under 425, without prejudice to the generality of 423 in itself and what I've just mentioned. So just going through that menu very swiftly. 1, you can require any property transferred as part of the transaction to be vested in any person, either absolutely or for the benefit of all the persons on whose behalf the application for the order is treated as made. 2, you can require any property to be so vested if it represents in any person's hands the application either of the proceeds of sale of property so transferred or of money so transferred. 3, you can order the release or discharge in whole or part any security given by the debtor, so mortgage, charge, lien. 4, you can require any person to pay to any other person in respect of benefits received from the debtor such sums as the court may direct. 5, you can provide for any surety or guarantor whose obligations to any person were released or discharged under the transaction to be under new or revised obligations as the court sees fit. And 6, you can provide for security for to be provided for the discharge of any obligation imposed by or arising under the order for such an obligation to be charged on any property that's related or released or discharged to the transaction. So incredibly broad range of things that the court can do. They can interfere with charges, they can interfere with guarantor and surety's liability if they find themselves wrapped up in the transaction. And that's why, going back to what I said earlier, if you've got the choice between a very difficult fraud case and you're thinking, well, I can get all these remedies, pleading and proving a 213 or a Part 7 claim in deceit or conspiracy, as opposed to having this might well be the better option. There are, of course, statutory limits to this under 425 sub 2. An order may affect the property of or impose obligations on any person, whether or not they are a person with whom the debtor entered into the transaction, but it cannot do one of two things. It cannot prejudice any interest in property which was acquired from a person other than the debtor and in good faith for value without notice, etc., or prejudice any interest deriving from that interest. And it shall not require a person who received a benefit from the transaction in good faith for value, etc., without notice of the relevant circumstances to pay any sum unless he was a party to the transaction. So if I may, it's a very souped up equities darling that's protected under this subsection.
So how can we forensic accountants help on this occasion, and when should you bring us? My first advice was bring us early. That's the most important thing. We can identify transactions at undervalue, I think. Oh, thank you. Review the financials of the company in question to identify transactions where assets have been transferred for less than the market value or where liabilities have been reduced without any compensation. The other way that we can help you is the evaluation of the assets, and I will leave that to my colleague Gavin to analyze more in due course. Tracing transactions and asset tracing and support you in the litigation. We can trace the funds and the assets that may be hidden or moved to other parties. By tracking down the assets, we can make it easier to challenge the transaction in court, and we can provide expert testimony in court. We can also assess intent and motive by analyzing their online presence, their lifestyle, and everything around the individual or the company in question. So the case of Akhmedova, Mrs. Akhmedova versus Akhmedov, if I'm pronouncing it correctly, it was the largest divorce case. I looked it up because I was interested, and it was the largest divorce case that has demonstrated the effectiveness of bringing a claim under Section 423. And it shows that it can be used outside insolvency, basically. So in this case, she was awarded $454 million, and just when the judgment happened around that time, the husband went and transferred to his son and a lot of other trusts all of his money so that she cannot enforce that. She got enforcement, and she got worldwide freezing orders. She got forensics being involved, and actually the son was so funny, and that leads to my next question. But the son was so funny to say that he has lost his password for the Google email. He cannot recover it. Then they tried to recover his phone. You remember it? They tried to recover his phone, and he sent it through with DHL and said that the packet was lost. It was a coincidence. He paid a guy. So it was quite interesting. So early is good, and gather the evidence and preserve the evidence is what you need to do on these cases. When should we be brought? If a suspicion that a company or an individual has entered into transactions under value, we should be engaged early to identify and analyze the financial, the contracts, the assets transferred, as well as doing a worldwide asset search, basically. If a claim is being considered, we should be brought to assist with gathering the evidence and presenting it to court. And if there is suspicion of fraudulent intent, we can investigate, as I said, outside the lifestyle and everything around the individual or the company. And you will ask me now, or the guys would ask me now, what are the limiting factors of us doing that? Multitasking. So the limiting factors are incomplete or missing records, often businesses that are under investigation, and not always under investigation. They will have incomplete, or they may have destroyed records that they may be crucial for an investigation, and the lack of information could hinder the investigation and our information, what we present on our reports. Cost and time constraint. Quite often, there is a balance of the cost of the investigation against the potential outcome of the claim, and particularly when dealing with large volume of transaction or offshore jurisdictions, the cost could be quite high, the time could be quite long. So that could also may limit the depth of the investigation and how much time or money we're given to do the investigation. And cooperation of third parties, as you may know, forensic accountants will normally deal with third parties to get the information, bank accounts, bank analysis, or former employees. They may not be willing to talk to us or put a witness statement through. So they're all limiting factors on what the outcome of our investigation will be. And then what tools could be used and what steps could be taken to enhance these investigations and preserve the evidence. I would say gather and preserve all evidence, all relevant documents to the transaction, the contracts, the correspondence, email addresses, WhatsApp messages, invoices, anything that can show the nature of a transaction. I have loads of war stories of people sending messages to themselves or other individuals thinking that they're clever on WhatsApp, or others that they're even recording on WhatsApp and narrating on top what they're saying. But with tools that we have, we can transcript that and find anything that they're saying in any language, basically. If possible, secure the documents that could suggest the financial position of the debtor before and after the transaction so that we can investigate that. Preserve the electronic evidence. As I said for the previous case, they will lose the passwords, they will lose their phones, there will be tons of phones and company computers that they will be sat in their office room, as in the same case, he had like 20 devices in his office that when they got the court order could seize. So all they should be uploaded on an investigation tool like Reveal or other online tools for us to analyze. Then we need to trace the transaction in question, analyze the bank statements, analyze the contracts, review the witness statements so that we can see if there was an intent to defraud or if it was actually moved at undervalue. The next one, which people quite often oversee, is perform an open source investigation on the lifestyle. If a husband normally would say to the wife, I do not have any money to deal with this judgment, most of the times they will come, and it's numerous times that clients are coming to us. It couldn't be that he lives this lifestyle without money. Like they have a yacht, they go every weekend in Monaco. So it is information that you will be shocked how much individuals are uploading. And if it is the individual that is defrauding, he will hide it. But the son, in this occasion, with that case, will post something that it will be reckless because he doesn't know, or the daughter or friends. The youngest and the eldest normally give everything online. Perform an asset tracing exercise to match the financial records to existing assets. Quite a few times we will have financial statements saying, I have these assets. The company says, oh, there's no assets under the company. Yeah, but how did you declare that? Where is it? You have some assets, there must be somewhere. Use state-of-the-art investigation tools, as I said, to do the online investigation, as well as review the documents, contracts, email reviews. Like Reveal, you can review it if you are a good user, but you can go down into rabbit holes and spend hundreds of hours trying to find out what is the smoking gun on whatever you're looking. And you need to act quickly. I cannot stress this enough, because once the assets are gone to an offshore jurisdiction, it will cost you most of the times 3 times the money to get a freezing order, get lawyers there, and get them recovered. So Over to you, Kit, now. Zach spoke a little bit about the great elasticity to the jurisdiction, including extraterritorial effect. But in our discussions, we discussed the recent case law, which suggests a defendant party does not even need to directly own an asset in question. I think you wanted to talk about this a little bit more to enlighten us.
Yeah, absolutely. Thank you very much, Effie. I suppose I'll probably start by saying it's been a pretty sweaty and clammy 48 hours leading up to this talk, furiously refreshing the Supreme Court judgment website to make sure that the lords and ladies haven't handed down their decision, and thankfully they haven't. So I can speak freely today, and it hasn't been overtaken by case law in the last 24 hours, so we're good to go. I'd like to start today focusing on the Investbank and El Husseini case in the Court of Appeal decision last year. It's raised a couple of very interesting points about the ambit of 423 and how you can use it alongside those usual fraud claims that you might see in pleadings. Forgive the slightly grandiose and pompous opening, but I think it's probably the most important recent case to shake up our understanding of 423 claims, and so I'm going to delve into it in just a moment. The case focused at appeal level on the first element of 423 claims, which Zach very helpfully unpacked a few moments ago, namely what amounts to a qualifying transaction. Now, two key propositions came out of the appeal. Firstly, it was held that a transaction can be caught by Section 423, even where the individual defendant entered into the transaction on behalf of a company he owns and controls, rather than in his personal capacity or on behalf of himself. So, as I'll explain shortly, basic rationale here is that the conclusion was that otherwise sophisticated fraudsters would simply interpose a corporate entity to sidestep the clawback provisions of 423. The second big point from the judgment is that 423 also captures transactions involving assets that the defendant doesn't even beneficially own. The court again took a purposive approach to interpreting this section to ensure that the interests of creditors are protected and again aren't easily sidestepped by fraudsters. So both these conclusions have been welcomed by practitioners, IPs, funders, the like. The flexible and broad scope of 423 is a very welcome development and cements its position as the ever useful tool in the fraud fighter's toolkit. However, as I mentioned at the beginning, all of this is, these propositions at least are subject to appeal to the Supreme Court, but whilst that judgment hasn't been handed down yet, the Supreme Court did allow the 8-week commercial court trial to go ahead earlier this summer. So that may provide a nod to the Supreme Court's thinkings, and perhaps they agree with the Court of Appeal. My bold prediction, for what it's worth, I think the courts have shown historically an aversion to overly strict interpretations of the law, particularly where rules surrounding separate and distinct legal personality are concerned. And the use of limited companies to avoid legal recourse is something that obviously is very unpalatable to the courts, and we saw that in Sevalea and Marix at Supreme Court level. The court will take a practical and purposive approach to interpreting the law to avoid creating a fraudster's charter. Now that may all prove to be wrong next week, so don't hold it against me if it is. So some of the key background from Investbank and El Husseini. Just before I dive in, just some sort of key facts for you here. The first respondent is a Mr. Ahmed El Husseini. He is a debtor under 2 UAE judgments, debtor to the bank in the princely sum of 96 million dirhams. The second to fifth respondents are his sons from his marriage to the sixth respondent, who is now his ex-wife, so he says, from whom he said he was divorced in 2017. And 2017 is quite an important point in the factual matrix of this case, because it's around this time that various transactions were entered into alongside the supposed divorce. Now, there are two limbs or two types of transactions that the court case is really concerned with: real estate transactions and the shares and money transactions. The real estate transactions concerned 2 Hyde Park Garden Mews properties, numbers 9 and 32 if you want to get on Rightmove quickly, and the proceeds of sale of 18 Hyde Park Square. Now, this property was transferred to a trust structure, or to a trust structure called the Spring Blossom Trust. The beneficiaries of that trust are, well, you've probably guessed it, the ex-wife and his sons, and it was established in, again, you've guessed it, 2017. So a very busy year for Mr. El Husseini, 2017. Now, Virtue trustees sold the property a few months later at fair market value, and to an unconnected buyer, I should add. So it's not all cynical, not all dodgy. And the proceeds were then transferred to his ex-wife. But returning to my cynicism, many of you will notice he's probably on unusually good terms with his ex-wife at this point. So, but I'm just a cynic. And then, of course, there's the shares and the money. There's some shares in a UK company, and $15 million of cash in a Lebanese entity owned and controlled by the debtor. Exactly. So now the debtor was said to have taken steps in 2017 to disguise the beneficial ownership of the properties and to put them beyond the reach of his creditors by transferring them to family members. This isn't a novel scenario for many of us in this room when we look at the usual sort of factual matrix of a fraud case. And you'll note from some of the transactions that I described that there is the repeated line of conduct whereby holding vehicles are used to hold assets, and then he procures the transfer away to connected third parties or family members. So that's a whistle-stop tour of the facts. If we could change the slide now, please. Brilliant, thank you very much. So we'll look at why the court considered that a debtor's acts can be the acts of a company. Because at first blush, this appears to offend the principles of separate and distinct legal personality, Foss and Harbottle, day one of law school sort of stuff. The bank's fundamental position was that the words of 423 subsection 1, a person enters into a transaction with another person, can and should be properly interpreted to read that a person who causes a company which he controls to enter into such a transaction with another person, that sort of scenario being captured by the slightly narrower wording. Now, this is on the basis that the step of entering into a transaction doesn't require a person himself to have made the formal act of transfer or himself to have been privy to the transaction, as long as it can be shown that he was involved in the transaction. That's slightly sort of open-ended and woolly, but good for us litigators in the room. The bank said that the High Court was wrong to say that its analysis was contrary to the fundamental principle that a company is a separate and distinct legal person from its shareholders, who have no proprietary interest in the company's assets, or that it sought to pierce the corporate veil. The bank pointed to several instances in law where personal liability actually attaches to the acts of directors. So that's misrepresentations made by, or statements made by directors when carried out on behalf of the company that are found to be misrepresentations, or where a director procures a breach of a contract by the company or procures a breach of a trust by the company. And the Court of Appeal accepted the bank's argument on this point. It said that it was important to recognize that even where an agent's acts are to be attributed to the company, the agent himself has still done something. So this is the key point, really, that while the debtor's acts are to be attributed to the company, they're not to be disattributed from him. And this is what you might have heard referred to as the disattribution heresy in the past. So just concluding on this point, the court thought that the narrow interpretation of 423 that was approved by the High Court was contrary to the protective purpose of the legislation. It would mean that a sophisticated debtor could destroy the value of the shares in his company by asset stripping, transferring the assets away to connected parties, family members, etc., and then have no fear about the clawback provisions of Section 423. So it was wrong to leave creditors without a remedy in such a situation when 423 was really intended to assist them in clawing back fraudulent transactions.
Thank you, Kate. So if I have summarized it correctly, separate and distinct legal personality will not frustrate a potential claimant's claim under Section 423. Does the transfer need to beneficially own the subject matter of the transaction?
In short, no. This is the other very interesting point that came out of the Court of Appeal decision, being that confirmation that subject matter of the transaction does not need to be beneficially owned by the debtor to be caught by 423 or for 423 to be engaged. Mr. El Husseini's legal team sought a very strict argument that the assets transferred away by him needed to be beneficially owned by him for 423 to be engaged. Unsurprisingly, this got short shrift from the court. But I think it's worth just having a think about what the reasoning was behind this argument. And it centered on a principle from a 1994 case called Clarkson, which essentially said that a transaction must involve the giving away of assets that would fall into a debtor's estate. And just going back a moment to the point about separate and distinct legal personality, a shareholder doesn't have any right or claim to the underlying assets of a company, even if he's the sole owner and director. So in that scenario where, such as Mr. El Husseini, those assets don't beneficially belong to him and can't fall into his estate. And so the point of Mr. El Husseini was it can't fall to be claimed by 423. So if you consider this a little further, if you take a situation where the debtor is the sole owner of valuable shares in a company, those shares are valuable because that company owns valuable assets, perhaps 2 or 3 properties facing into Hyde Park. And of course, it's trite law that the shareholder owns no interest in the underlying assets, even where they're the sole shareholder. So whilst the assets of the company are not beneficially owned by the debtor, they may be within legal reach of creditors of the company. There could be, if you have a judgment against them, you could have enforcement proceedings, you could have an order for sale, and the creditor could take hold of the shares of the company and then vote to sell the assets, liquidate them, and declare a dividend to the shareholders. So it's not necessarily beyond the reach of creditors. So the Court of Appeal dismissed the debtor's appeal on this point, and of course the Supreme Court judgment is eagerly awaited at this point. The debtor could enter into a transaction at an undervalue for the purposes of 423, where assets transferred were not beneficially owned by him. And the judge hadn't erred for three principal reasons here. Firstly, the broad language of Section 423, particularly subsection 3, doesn't require the transfer of any assets, let alone the transfer of assets beneficially owned by the debtor. So to say otherwise would require us to read in words that just aren't there. Secondly, there's no obvious policy reason for a more restrictive reading of this section, whereas there is a very good policy reading for construing this section in a way which would give better effect to its purpose in order to protect creditor interests. Were such a restrictive reading favoured, as I've mentioned, I think it would form a pretty simple and easy fraudster's charter, and it would also denude Section 423 of any real bite or power. It would also do all of us out of a job, really, as well, but that's another point. So thirdly and lastly, there was no requirement to construe the phrase enters into a transaction in Section 423 in conformity with the use of that phrase in Sections 238 and 339 of the Act, since those provisions concerned instances or arise out of instances of insolvency, whereas 423, as Zach has helpfully mentioned, is not confined to insolvency situations. Now, two brief final points, and then I promise I'll move on. There's something of a legislative tension at the moment, as I've just alluded to. The interpretation of a TUV under Section 423 is broader than in Sections 238 and 339 of the Act. And all these provisions use materially the same language to define a TUV, so why should 423 be different to 238 and 339 in this sense? Clarification on this point is something that will hopefully come in the form of the Supreme Court's judgment, but obviously that is still awaited. And just a final point here, whilst beneficial ownership is not a necessary ingredient for a successful 423 claim, as the Husseini case has demonstrated, without it establishing that prohibited purpose that Zach helpfully identified earlier, it's going to be very difficult. And this was a point that was touched upon in the Lemos and Church Bay case last year. If a debtor is moving an asset in which he doesn't hold a beneficial interest, it's very hard to see without a unique fact pattern how that transaction is designed to defeat or defraud his creditors, whether actual or in the future as well. So just touching upon Effie's point, really boring down into the evidential detail, why that transaction of an asset that he doesn't hold a beneficial interest in, why is that a transaction defrauding creditors? It's something that really places a lot of emphasis at the pre-action phase, I think.
Thank you, Kate. So the jurisdiction is broad. The transaction does not have to be entered into by the debtor himself, and he does not need to own the assets beneficially. But what if the debtor is evasive? Is the debtor the only party who can be sued under Section 43 now?
No, and I think it's a really good point, because obviously, we all know in this room that fraudsters are very sophisticated. They are coming up with newer and newer ways to try and defeat judgments, whether those judgments have been handed down, whether they're foreseeing them in the future. They are becoming more and more creative. So I think this has been a very helpful decision from Integral Petroleum and Petrogat to widen the ambit of who you can go after under a 423 claim, and who may be found liable for those claims. The key question in Petrogat was whether a 423 claim could succeed against de facto directors of Petrogat who'd emptied the company's bank accounts and transferred its funds to another unknown company. And thereupon they refused to identify, pursuant to a court order, who that company was. And this was to avoid the arbitration award and while the arbitration was ongoing. And for the Marex nerds like me in the room, there's something similar to that fact pattern here. But because the de facto directors had refused to identify the recipient company, there was no direct evidence before the court that they'd received a benefit from the purportedly fraudulent transaction defrauding creditors. And this is a fundamental point with 423, because there is authority to suggest that there is no jurisdiction to grant relief against defendants to a 423 claim where they haven't received any benefit themselves. And that's been confirmed in the cases of Wilson and Masters International and Johnson and Arden, because the fundamental point is that 423 is restitutionary in its nature. However, in Petrogat, the judge also cited Mr. Stephen G. Casey's book, which I'm sure we all know very well, on commercial injunctions, whereby it's been said that this isn't the correct position, actually. The judge was reluctant in Petrogat to read into 423 a jurisdictional hurdle regarding receipt of a benefit that was not apparent on the plain wording of the provision. Instead, he concluded that the de facto director's refusal to disclose the identity of the recipient company allowed him to draw an inference that they'd received some benefit from the transaction, at least equivalent to the amount sought by Integral. And that enabled him to make an order under Section 43 against them for the sum sought. The judge also observed that it was a bit of a catch-22 really for him, because if he hadn't reached this conclusion and made such an order against the de facto directors, it would have had the sort of odd or startling consequence that their refusal in breach of the court order would benefit them. They had to explain where the money had gone, and had the judge not made this order, it would have had the effect of depriving the court of the ability to make any effective relief or any effective order against them. So again, that would have created a very simple fraudster's charter: breach a disclosure order, pull up the drawbridge and disappear off to your Caribbean island. But obviously that didn't transpire. So look, just in conclusion on that point, I'd say this is another example of the court's willingness to use its wide discretionary powers under 423 to ensure that the parties who appear behind fraudulent transactions are actually held to account and can't defeat it through nefarious means. But I think with that, I will finish and hand over to Gavin to consider the real money question, quantum.
I'm glad you didn't say the real money question, how much forensic accountants charge for their work. So what would we generally get involved in? Well, it would normally be valuing shareholdings or whole companies where they've been transferred. And actually, it's interesting, before I come on to the kind of what we're really talking about, we do sometimes get approached, whether by some of our insolvency colleagues or by people introduced to on the other side of the fence, say, look, we're doing a transaction, can you help us support a low value? And the answer is always no, because it needs to be credible. And I'll end on this point as well. But most of the time we'd be getting involved in a claim like this is because there's been a transfer. Someone thinks it's at undervalue. Maybe the insolvency practitioner, maybe the solicitors, maybe a litigation funder actually wants someone to look at it and see what the true value of the company or shareholding was at the date of transfer. And it's pretty simple what we'd normally be doing. We'd be looking at the contemporaneous facts to work out what the value was as at that date. And I emphasize the contemporaneous part because hindsight can be very dangerous in these situations. And I have been involved in cases where actually there was very little value, a business has been transferred and it has done well, maybe because someone's invested a lot more money in it or because there's been a fortuitous event. A large proportion of the time, that's not our conclusion, but there are sometimes smoking guns in these cases. At the end of the day, the real difficulty was alluded to by Effie in terms of gathering information, and that's we very often don't have the contemporaneous information we need to really establish value. Because when we're doing evaluation, what do we need? We need up-to-date accounting information, management accounts, etc. Often, particularly in an insolvency situation, they may not be up to date. More relevant sometimes, there's been deliberate destruction or removal of records, which means we don't have them. So it can be very difficult to have that key documentation that allows us to reach a contemporary valuation. The real issue is that it's often smaller businesses you're dealing with. Valuation is forward-looking, and the key thing is what's the business going to do in the future. Often these kind of businesses don't even prepare forecasts or budgets, let alone have them. And these are all factors that make it really quite difficult often to actually establish what the value was, which unfortunately often makes it easier for defendants sometimes to fight these claims because they can say, well, look, you don't have the information to support this. So, as part of that, it's often key to see what other information there might be that supports that there may have been an undervaluation. And it can be literally a smoking gun. I was involved in a slightly different case, but where the directors, a couple of weeks before saying the business was worth nothing, effectively prepared a set of forecasts that they gave to investors saying that they thought it would be worth 15 million in 2 years. Now, in that instance, it's quite hard to argue, as the judge found in that case, that there was no value at the date that they were trying to claim that. It's obviously not always that clear, but as Effie alluded to, there are often documents beyond the accounting records which can be helpful when we are establishing value.
So how do you quantify the losses incurred due to the alleged fraudulence?
Well, we could do a 2-hour session on that, but
No, in a nutshell.
But look, at the end of the day, what we are doing is valuing the company or shareholding at the date and comparing it to what it was actually transferred for, which is obviously quite often nothing. In terms of valuation techniques, I'm sure most people will know, but there's 3 main ways of valuing a business. There's a multiple approach where you take EBITDA or another form of profits. There's a discounted cash flow where you look at the future expected performance and discount it back. And then there's the balance sheet. It's often hard doing the discounted cash flow because, as I say, you don't have forecasts. So it's normally either looking at the profits or looking at the balance sheets. But a couple of caveats to make on that. Where you're looking at the profits, you can obviously have companies that aren't profit making that can have significant value. You know, it's not just the kind of, tech type businesses that you'll read about, where transactions are undertaken at massive multiples or infinite multiples where they're loss making. It's also, if you've got a startup or if you've got a business that's currently going through a bad time, they might have had a huge amount of bad debts in the last year, they might have lost a contract, but it's a fundamentally strong business. So losses don't mean no value. On the counter to that, on the third valuation basis, the balance sheet, a lot of people will look at a company's balance sheet and say, it's got net assets, it must have value. That isn't necessarily correct because it will depend what the assets are and how recoverable they are. For example, goodwill on a balance sheet is often meaningless. It's whether the company actually really has that goodwill. You might have a load of stock. It might be, that it needs to be written down. Similarly, there might be assets that aren't on the balance sheet or have been undervalued. So if you've got property, obviously, you need to make sure it's included in its market value. But what I caution, because this is something we see quite a lot of lawyers, they'll look at a balance sheet, see a positive net asset value, and automatically assume that's the value, which it isn't necessarily. One complexity to also add in is you'll sometimes have companies that effectively are struggling, may go under, but if they have a cash injection, they could have a significant value. I've been involved in one where actually, by someone putting in $1 million, it reaches a 10 million value because you kind of fund the next stage of development. Say you've got a product ready to go to market, but it needs more investment. That's a really difficult one, and I think it's, there's no easy answer other than, it's one to fight, but be aware of the difficulties because the other side will say, well, look, it would have gone under if the money wasn't put in. So I'm going to go full circle back to where I started, which is if you're advising someone who's considering undertaking a transaction that could be considered to be undervalued, do get a proper valuation at that time. Do get it from a proper valuer. I mean, I recently saw a one-pager which said, "Dear Jeff, I valued your company at 100,000 as you asked, is this okay?" and that is literally pretty much verbatim what it said. Get something credible that actually looks at the situation at that time. Actually, if it's done by someone bona fide, that's going to be pretty persuasive and likely to avoid these issues coming back.
Thank you, Gavin. Zach, over to you to finish off, and I will caution you on time. What ancillary applications should a Section 423 claimant consider?
Let's talk about freezers.
The fun thing.
The really fun bits. The Integral Petroleum case, to which Kit referred to earlier, has a long background, and in particular is a useful example to look at of how freezing orders and worldwide freezing orders are particularly relevant to protecting a claimant's position in a 423 scenario. In Integral, Mr. Justice Calver granted an ex parte worldwide freezer, which was continued on notice by Sir Michael Burton, and the reference to Sir Michael Burton's judgment is up there on the slide. And it makes plain sense, as I was saying at the start of this talk, that such injunctions should be available here, bearing in mind that the underlying nature of a 423 dispute involves an impugned transaction for the purpose of placing assets out of a claimant or potential claimant's reach. Sound familiar? So this leads me to an important development that I'm sure we've all heard about over the last few weeks in the freezing injunction, the very recent case of Dos Santos and Unitel SA, again up on the slide from earlier this year, which has arguably, we'll see in a minute, redefined the test for freezers. So by way of recap, the traditional test for an interim freezing order would have included 4 elements: cause of action with a good arguable case, sufficient assets in existence to meet the claim, a real risk of those assets being dissipated, and finally, it being just and equitable to grant an order. And of course, that's Section 37 of the Senior Courts Act 1981. A good arguable case has often been thought of as a more stringent bar to surmount than the usual merits assessment for other types of interim injunction, i.e. a serious issue to be tried, the classic American cyanamide test that we all know and love since law school. And this was thought of as appropriate because of the serious nature of a freezing order. It's very, very invasive, and you can go back to cases like Hollyoake and Candy, Mr. Justice Nugee as he then was, and look at Dos Santos at paragraph 106 in relation to that history. However, that thinking, according to the Court of Appeal, is now erroneous, and the 2 tests are to be equated. A serious issue to be tried is one that will meet the summary judgment threshold, i.e. it has a real prospect of success, it is not merely fanciful. And that's Dos Santos at paragraphs 125 and 126 per Lord Justice Popperwell. Now, what does this mean for practice? Does this really change much apart from clarifying the applicable test? If you're seeking a freezing order for a claim that is on the borderline of the summary judgment threshold, you may well have bigger problems to surmount than worrying about the wording of the test. And an interesting comment from Lord Justice Popperwell at paragraph 128 of Dos Santos highlights the way in which the freezing order jurisdiction has developed over the decades to become a very regular and powerful commercial tool. And I quote, "I readily accept that freezing order relief is invasive, and no one with experience of how such orders operate on defendants in practice can be unaware that in some cases they can operate harshly, and not only by reason of the disclosure requirements which often accompany them. In the past, such orders were famously described by Lord Justice Donaldson in Bank Mellat and Nikpor from 1985 as one of the laws to nuclear weapons, although the number which are now granted in the business and property courts suggests that this description is inapt, dating from a time when the jurisdiction was in the infancy of its development. It now has its justification firmly rooted in the protection of prospective rights and interests in what is termed the enforcement principle. Although there are important differences between freezing orders and other types of interim injunctions, there seems to be no justification for a different merits test in the nature of the interests being protected. For interim injunctions, the right being protected is a substantive legal right, assuming it to be a substantive right which will be vindicated at trial by a judgment. For freezing orders, it is a legally protected interest in a judgment being enforceable, again on the assumption that there is a substantive right which will be vindicated at trial by a judgment. The same prospect of establishing the substantive right at trial should stand as the merits threshold for both. So this is a very interesting new way of looking at these things. Back in the day, and I'm a fraud lawyer by majority of my practice, when you would defend an alleged fraudster, capital A alleged, you would receive a ex-parte freezing order served on you, and if you couldn't properly challenge it or have it set aside, you'd have in the back of your mind thinking, well, they've got a good arguable case here. They've already established that, and so I've got one arm tied behind my back. But this is quite an important comment from His Lordship, Lord Justice Popperwell, to remind us, well, no, that's not right. These are just injunctions to protect the position. But it might well turn out down the line that this fraud case doesn't have legs to it and will fall apart once you get to trial in the cold light of day. So I think it's the right judgment. I don't think it changes much in practice apart from perhaps our mindset as fraud lawyers, but I think that's an important change, certainly. And I commend, again, I've commended a lot of reading to all of you, including Anna Karenina today. I commend reading that judgment as well. Now, if a freezer proves insufficient in protecting a claimant, prior to the determination of their claim. A further source of relief, although currently not as popular as it should be, and I'm probably going to go on about this because I'm co-editing a volume of Atkins on the subject, so there you go, try and make it popular, is the appointment of a receiver by the court under CPR Part 69 in support of a freezing order. So the receivers actually come in, take the property, control and manage the property if you've got a management order, and safeguard assets. And the leading case here is one of the Ablyazov judgments, which is on the slide from 2010, across that very long-running saga that I needn't remind anyone of. Per Lord Justice Maurice Kay's judgment in that case, if a freezing order does not of itself provide adequate protection to a claimant because there is a measurable risk, and that's the test, there's a measurable risk that the defendant may use some kind of structure to sidestep the freezer and get away from the effects, bearing in mind, of course, a freezing order does not have proprietary effect, then a receivership order will normally be justified. Now, Mr. Ablyazov in that case had breached his disclosure obligations under the freezing order by failing to reveal lots of assets that he held in lots of complex trust structures, as the story goes. And that's what led to receivers coming in, taking control of the assets subject to the trust, making sure that they weren't being dissipated and making sure that they could have a proper account of those assets. So it's a useful tool. Don't forget about it. It's very, very rarely used these days, still in fraud cases, and I commend that as well. Although, remember, it is an even more invasive tool than a freezer, so you need that measurable risk, and normally you don't have an application for both at the same time. You get the freezer, you see if they'll comply, and then you very quickly go for the receivership order.
So we're finished. I will give the word to Zach and Kit to do some conclusions, and then we have some questions if anyone has any questions to ask, because we're 5 minutes delayed.
Do you want to bat first, or will I?
I'll bat first very, very quickly. Three conclusions. 423, incredibly broad, fantastic to use, might not need to prove fraud. Excellent. Second one, a freezing order can of course be used to support a 423 claim. It's not only there as a tool for fraud actions, so always remember that. And bearing in mind what Lord Justice Popwell has said, it's going further and further away from being considered this incredibly invasive thing that you use against an oligarch who's defrauded a bank or something like that. And then finally, the receivership point. Of course, read my volume of Atkins. I'm just kidding. But do read Part 69 and have a think about that, and have a think about the Ablyazov judgment, because it is a useful tool in the right circumstances.
Kit, over to you.
I'll pick up briefly on the freezing order topic. Don't forget the Chabra freezer as well, freezing third parties who might be holding those transferred assets as well. So that's wonder whether maybe a little renaissance for the Chabra freezer with the expanded scope of 423. But I think the important thing today that today has hopefully shown is that the pre-action phase with the 423 claim is essential, is of the utmost importance. A case can be won and lost at the pre-action phase. So you have to have your evidential house in order early on. So a plug for Effie and for Gavin. Often these cases span back many years. You think of Sands and Clitheroe case where they were clawing back a property transferred 15 years earlier. So have your evidence and chronology set out in forensic detail. This obviously helps to prove the prohibited purpose, which Zach mentioned earlier. That's obviously a big and very significant hurdle to clear. If you're in an insolvency context as well, then remember the office holders obviously have very wide powers to interview for disclosure under the Insolvency Act. So think about sections 235, 236, 366, to require a debtor or any person connected to give an interview, deliver up books and records, etc. Helps paint the sort of evidential picture that you'll need to get this off the ground. I think, just to conclude, I think there's a higher evidential bar required at the pre-action phase for a successful 423 claim than there are for other types of claim, particularly those featuring TUVs. But against that, you have the benefit of extraterritoriality, no time limitation, etc. I think this challenge, though, is probably reflected in the data, which suggests that only, I think, in the last 12 months, 9 423 claims have been brought in the High Court. So on that scintillating numerical note, I'll finish.
Thank you all. If you need to talk to us, we'll stay a little bit longer if you have some questions, but I think we need to leave you all go to your next session or whatever, your lives. Thank you so much.
Thank you.
Cheers.